We'll hear argument first in Case 13-628, Zivitofsky versus Kerry. Ms. Lewin.
Mr. Chief Justice, and may it please the Court, how an American is identified in his or her passport or U.S. consular report of birth abroad, including the place of birth designation, does not amount to formal recognition by the United States of that designated location's sovereign status. This is the principal reason why Congress's law authorizing Jerusalem-born citizens to carry passports that say they were born in Israel is a legitimate congressional exercise of Congress's power to regulate foreign commerce.
Suppose that the President and the Secretary of State put on the passport the place of birth, I've written it out, the place of birth on this Jerusalem-born citizen's passport has been listed as Israel at the holder's request. This designation is neither an acknowledgment nor a declaration by the Department of State or the President of the United States that Jerusalem is within the borders of the State of Israel. Could the President, under existing statute, and the Secretary of State, under existing statute, put that statement on the passport?
Yes, Your Honor, they could put that statement on the passport.
What do you think if Congress then passed a law saying that statement had to come off every passport? Could Congress do that?
Yes, Justice Kagan. There's no restriction on the initial granting of recognition by the President, but by the same token, the Congress has the ability afterwards, upon deliberation, to decide if they disagree with that recognition. But in the case that Justice Kennedy
has that ever happened?
Yes.
In the history of the United States, where Congress, after the President had declared that it was not recognizing someone, has Congress ever recognized?
Yes, Justice Sotomayor. In 1898, Congress passed a joint resolution for the recognition of the independence of the people of Cuba over the initial opposition of President McKinley, and that ended up recognizing the independence of Cuba.
You were careful to say at the outset that this is not recognition. The Court of Appeals decision, I think it was in the Judge Tatel concurrence, said that both parties urge upon us that the power of recognition is involved here, and Congress has done it. And then, of course, the Attorney General takes the opposite position, that this A, this is recognition, and B, that's why it's void. Did you change your position here, or am I just misinterpreting the way that the Court of Appeals
We've provided to
discussed it?
Alternative options for resolving this issue. Our primary position, as I said at the outset, is that what is written in this statute does not amount to a formal recognition of sovereignty, because the language of the statute itself is very narrow. It begins by saying that for the narrow purposes of recording a place of birth on a passport or a consular report of birth abroad, that is what this statute provides for. It also does not state that in all circumstances you have to list Israel as the place of birth. It is merely giving the individual choice.
The provision is part of a section 214. And I think you're trying to read G as though it is disassociated from the purpose that's expressed throughout 214, that is, that Jerusalem is the capital of Israel. Congress said that. And you are trying to deal with a piece of one section without regard to the thrust of the whole provision that Congress has said, we think Jerusalem is the capital of Israel.
Justice Ginsburg, that is correct. This section of the statute should be reviewed and the constitutionality of it be determined on its own. But the Court should look not at what Congress may have intended by the entire section, but rather what this section actually did. And this section, as I said, gives the individuals a choice and does not confer formal recognition. There are benefits that come.
May you say that, but you say I've heard exactly what you say, and I think that's certainly a reasonable position. You could read this and say it doesn't really say anything about recognizing anything. But the Solicitor General of the United States, after conferring with the State Department, says, since Israel's founding, every president has adhered to the position that the status of Jerusalem should not be unilaterally determined by a party. And he adds, by requiring the president to contradict his recognition position regarding Jerusalem in official communications with foreign sovereigns, the section unconstitutionally encroaches on the president's core recognition authority. So he has a different view. He thinks it is our policy not to recognize Jerusalem as the capital, which you apparently agree with, and he thinks that this does have some tendency, at least, to suggest the contrary. Now, I'm a judge. I'm not a foreign affairs expert. And when he tells me that, and they are foreign affairs experts in the State Department, how can I say that I'm right even if I agree with you, and they who are in charge of foreign affairs are wrong when they make those two statements, which certainly sound plausible?
2 points, Justice Breyer. The first is that what goes on a passport as a place of birth is not tantamount to recognizing foreign sovereignty. Taiwan is a perfect example. The State Department
I must interject at this point because you emphasized the Taiwan example, and it seems to me it's most distinguishable. Taiwan and China maintain from the beginning there is only one China. And so Taiwan is a place name. It's a region. It's in no way recognizing, there's no question of recognition in the Taiwan example.
That's correct, Justice Ginsburg. So what you put on the passport does not automatically
to go back to my question, which I'd like an answer to. I don't think that Taiwan is a counterexample, since the policy of the State Department in that thing that's FAM, which are the Foreign Affairs Manual, says pretty clearly that if there's a dispute about the larger power, i.e. China, you always can put in your passport the smaller place of birth, like a city, or I would think here Taiwan. So I don't hear the Department, who are, I guess I'm saying the experts, saying that the Taiwan example conflicted with their policy.
China objected to that. Did
China may have done. I want an answer to this question, not whether China objected or didn't object or so forth. I'm not interested in that. I'm interested in what we as judges do when the State Department and those charged say those other things were not contrary to our recognition policy. That's what they think. And this is.
So one last point on Taiwan.
I'd like the first point. What am I supposed to do?
Well, the first point is that what goes on the passport does not confer the benefits of formal recognition of sovereignty. This does not entitle the government, the foreign government, to bring cases in our courts to the protection of sovereign immunity or to the active state doctrine. What goes on a passport, therefore, does not amount to sovereign recognition.
Ms. Lewin, I thought your position was you couldn't care less if the State Department thinks that this is going to interfere with our relations with the Palestinians, that Congress is entitled to do what it is authorized to do under the Constitution, even when that contradicts let's assume they can't recognize a country, but they can declare war on a country, can't they? That the State Department has decided to recognize and to be friendly with.
Yes, Justice.
Congress can do that.
That is correct. Congress can do that, and the test if
and you say it can do the same here. And the fact that the State Department doesn't like the fact that it makes the Palestinians angry is irrelevant.
Absolutely, Justice Scalia. That is correct.
Right. And if you take that position, which explains it, then what do you think of Justice Story, who writes in 1833 that the exercise of the prerogative of acknowledging new nations and ministers, and he makes clear that that involves whether a city or a region is part of a country, etc. He says it's an executive function. Some argue, as I think we've just heard, that Congress could make that decision too, but that hasn't been decided. And he concludes that a power so extensive in its reach over our foreign relations could not properly be conferred on any other than the executive department will admit of little doubt. So he is saying, of course you have to have one person deciding such a thing, and that has to be the executive. That's 1833, pretty knowledgeable about the founder's intent.
But that is a rather extreme position, number one, to suggest that the executive branch would have not only the authority to recognize a foreign government, but also at the State Department say so. That automatically would end the question or any review by any other branch. The State Department merely says that the
But wait a minute, there is always review with the power of the purse. And there's always review with not appointing an ambassador. There is review in a variety of alternative ways by Congress. It just may not be the way you prefer, that they could pass a resolution contradicting that. That would have any legal force.
There is review, and even both to respond to you, Justice Sotomayor and Justice Breyer, Justice Story and William Rawle both recognized that authority of Congress to review. Justice Story also said that if such recognition is made, it's conclusive upon the nation unless indeed it can be reversed by an act of Congress repudiating it. And then he went further to say that if the President refuses to recognize, then he said Congress may notwithstanding solemnly acknowledge the sovereignty of the nation or party.
I suppose you could also say Hamilton in 1787 or whatever it was, Trump's story in 1830, right? I mean, he said pretty much the exact opposite, that the recognition provision was really just a trivial formality.
Hamilton also switched his position before he was in the administration and after in the administration. What that would seem to show, Mr. Chief Justice, is that it's not clear the history.
But in any case, this is not your main point, is it? You're being either forced into or willingly yield yourself to arguing that against the proposition that if this is recognition, it is invalid. But your main position is this is not recognition. It just has an effect on the State Department's desire to make nice with the Palestinians. And your position is Congress has no compulsion to follow that, assuming it can't recognize.
That is correct.
You don't claim that this is recognition.
We do not claim that this is recognition. In fact, there is a
Did you ask one factual matter I'd like. I see in the record that your application for the passport asked for Jerusalem, Israel. But that was changed. Was it changed in litigation? Was there an actual official request to change it in your application?
The initial request was made purely because of a misunderstanding of what the law initially required.
Let me just answer my question. Did you apply formally to have it changed, or did you just take that position in litigation?
The position was then subsequently taken in litigation, but in subsequent renewals of the passport, too, it has been just the request of Israel be put on the passport, and it has come back with Jerusalem.
May I ask you another factual question? When Menachem was born, was he issued a birth certificate by the Israeli authorities?
Yes.
And the United States recognizes that as a lawful exercise of Israeli authority to issue a birth certificate for a child born in Jerusalem?
I believe they do, Your Honor.
So this is a question I would ask the Solicitor General, but I don't completely understand what the position of the United States is regarding Israeli sovereignty over Jerusalem. I understand it is the position of the United States that Israel does not exercise full sovereignty over Jerusalem, but in this instance, the issuance of a birth certificate and others I can think of, I suspect the United States recognizes that Israel is lawfully exercising attributes of sovereignty over the territory of Jerusalem. Is that correct? So if let's say an American citizen committed a crime in Jerusalem, would the United States take the position that the Israeli government has no lawful authority to prosecute that person for the crime?
I do not believe so, Your Honor. I believe that they